Okay. Okay. Assalamualaikum everyone. Thank you for joining our Know Your Rights series, episode number 7. Housing rights. What landlords and tenants need to know. Today we're joined by Marissa Cohen. She is the Director of Education, Outreach, and Advocacy at Metropolitan St. Louis Equal Housing Opportunity Council, and our very own Huma Shah.
Hi, good evening, everybody. Thank you for joining us for our latest Know Your Rights event. We are going to be talking about landlord and tenant rights. Housing is a right that affects a lot of us, and Marissa Cohen will be discussing the issues that we face in this area.
Thank you. Thank you so much for the introduction and also for inviting EHOC to be a part of this conversation. We hope that you all gather some information out of this, and if you have questions, feel free to put them in the chat. And we'd be happy to answer them. If I can I go ahead and share my screen? Awesome. Alrighty, so as mentioned, my name is Marissa Cohen, and I'm the Director of our Education Outreach and Advocacy Program. And today we're going to talk about fair housing rights, as well as landlord-tenant rights. And with that, we'll just start off by talking a little bit about EHOC first. So EHOC is a private nonprofit fair housing organization, and we help people who feel that they've been victims of housing discrimination. And so it's our mission to work to ensure equal access to housing for all people through education, counseling, investigation, and enforcement. So that really speaks to our primary departments. And with that, we go out, in our education department, we go out and we give these workshops to community members, to nonprofits, to realtors, anyone who housing affects, which essentially is everyone in some way or another. And then also we have our counseling program. And so this is how people are able to access our services. It's through our hotline. And we have a housing discrimination hotline, a landlord tenant hotline, as well as an eviction defense hotline. And then we also do investigation. So investigation is what makes fair housing agencies unique across the country, because we go out and we do tests of housing discrimination. We go out and test claims of housing discrimination. And this is an opportunity that is available to anyone to take part in as in terms of a volunteer. And it does come with a paid stipend. And so if you're interested, we can connect you with our testing director if you're interested in helping us to further enforce fair housing rights. And then, of course, we have our enforcement department, which we also have staff attorneys on our team, as well as legal interns that assist with enforcing fair housing laws and helping people file or refile lawsuits against those that are doing housing discrimination, actually. So, and then we also have our eviction prevention program. And this was a program that we recently added as a result of the pandemic, because of the number of evictions that occurred during that time, and before and after all of the eviction moratoriums were in place. And so now this program does have some screening requirements in order to receive funds, but we're able to help with housing resources and assist others with relocation and things of that nature. But one thing to note about all of our services is that generally they are free of charge. They do not come with income eligibility requirements or limitations, and we work throughout the metropolitan region. So especially as it relates to fair housing concerns, we are all throughout Missouri or St. Louis, as well as parts of Illinois and the surrounding counties as well. So all right, so to get started, I will walk through some basic fair housing rights. And this is just important to keep in mind, because oftentimes we're not aware, right, of the law and what it states about fair housing and how housing discrimination can show up in a number of different ways. So to start off, the Fair Housing Act was passed in 1968, and a very broad definition of the law is that it prohibits discrimination against protected classes during housing-related activities. This is just a very basic definition of the law that speaks about two components: protected classes and housing related activities. And so that's what we'll break down just a little bit for you to keep in mind. But one other thing to note is that it is considered to be the last legacy of Martin Luther King Jr. And that's because it was passed 7 days after the assassination of Martin Luther King Jr., after having sat in Congress for 2 whole years. And so this was one of the last pieces of legislation that was passed that he was actively a part of advocating for during the civil rights movement. So, like I said, the protected classes. Who are these protected classes? What does that include? So this includes race, color, national origin, religion, gender, disability, and familial status. A couple of things to note is that disability and familial status were actually added once the law was amended back in 1988. And so they both allow for what's called affirmative marketing, meaning housing providers can say things like, we welcome family with children here, or, you know, we have wheelchair accessible units, or universally designed units, different things that may speak to characteristics within as for people with disabilities that they may be looking for in their housing, as well as families with children. On the reverse of that, when we talk about some of these other protected classes that we see with national origin discrimination, right? People being maybe treated differently in their housing because of their national origin, maybe given different terms or conditions of their lease, or increased stipulations, or even harassment, right? These are things that we see often, especially in housing. But I will say the number one complaint that we receive across the board is for disability, people with disabilities. That is the number one complaint. And in the metropolitan St. Louis area, race is the number two complaint that we receive. So when we talk about the housing and housing related protections, this is the part that I like to break down just a little bit, because it truly does encompass any way that housing is impacted. So it can be renting, but it's not limited to those who are renting. It can be those who are buying or selling their home, those who are obtaining or refinancing a mortgage, obtaining homeowners insurance, occupancy permits, or dealing with zoning or occupancy issues. And this is something that we see often as well, where maybe someone is being told that they have to have a 3-bed or a 2-bedroom unit because it's a mother and their child, versus having a 1-bedroom in other cases where there may be a spousal relationship. So this is another example of familial status discrimination. Oftentimes people being denied that access to, say, a 1-bedroom apartment when they standardly can fit 2 people in 1 bedroom. And then also with viewing real estate advertisements. And so this really includes, you know, any form of publication. So if it is posted on Craigslist, if it's posted on Facebook Marketplace, if it's printed in a newspaper, any way that this is publicized, any form of publication is considered an advertisement under the Fair Housing Act. So blatant statements saying no children allowed, or no men allowed, or no women allowed, these things would be considered discriminatory under the Fair Housing Act. So at local levels, we have additional protected classes, and this basically means that in addition to those federally protected classes that apply to everyone across the country, at a state level, there's an additional protected class for those for ancestry. So meaning that a person cannot be denied housing based off of, say, for instance, their ancestry. If there is someone who comes from a family of immigrants and they're being told, oh no, we won't rent to you, or we won't sell to you because your family are immigrants, that could be an example of an ancestry discrimination. Or even stating because of a person's last name, oh, we have history dealing with this family, or we have feuded in the past, where we've had fights in the past or disagreements in the past, and I don't want to rent to you because of your last name, your lineage, right? That's another example. It's something that we don't see as commonly, but that's not to say that it doesn't happen, because sometimes when people aren't aware, we don't make a complaint about it, right? We just move on and we go on to the next option. And so it's something to keep in mind. I think that's what a lot of this information is to say, hey, second guess some things that may just not seem right and let us know what's happening so that we can go out and we can further see, you know, is this discrimination happening to everyone in this regard? And that really helps us that helps our community to be safer, our housing choices to be safer. So moving on, we also have additional protected classes in some municipalities in St. Louis County, which includes sexual orientation and gender identity. And one thing that I forgot to mention is that recently the Biden administration actually passed a guidance that interprets sex, the protected class sex, to include gender identity and sexual orientation at a federal level. And so prior to this was there was a need for this additional protected class at local levels in the county and the city, because it was a little unclear if these things were protected. But now it is much more clear that sexual orientation and gender identity is protected in St. Louis County and in St. Louis City, as well as at a federal level. One thing that I want to note as well is the source of income protection in St. Louis City. Now, this does only apply to St. Louis City, but basically it's an ordinance that states that any lawful source of income should be counted towards housing. And this includes things like matrimony. This includes Section 8 vouchers, right? So when people or landlords are saying, no, we don't accept Section 8 or we won't accept Section 8, that can be in violation of this ordinance that is in St. Louis City.
Marissa, sorry, not to interrupt you. Can you just explain Section 8 a little bit to those people who might not know what it is?
Yes, so Section 8 is a housing program. It's actually, they've changed the name to Housing Choice Voucher. So it is a housing choice voucher that allows people to essentially use, you get into the program through the housing authority, the St. Louis City Housing Authority or the St. Louis County Housing Authority. And what it does is it provides a subsidy or governmental assistance to pay for a portion of your housing costs. And it requires that the individual who receives a housing choice voucher pays 30% of their income. And so in some cases, if you are making, you know, you have to meet the qualifications and the income qualifications in order to receive the voucher. And so from there, then you're paying, you know, a portion of your income, which it's not always, it will be proportionate to your income, should I say. So if you don't make any income, then you can have $0 rent payments and the housing authority is covering the full 30% cost or the full cost of your rent in some cases. And so it is a program that's extremely beneficial for people to seek housing mobility, right? So to get from a place where they cannot afford housing and then getting into a place where they, you know, maybe are able to save and not, it does protect them from some of these astronomical rent rises, right? That we're seeing right now even, but there is an extremely long wait list and the wait list does not open on a consistent basis. It opens very infrequently. And sometimes it takes years for people to actually get accepted into the program. We actually just had a client after 10 years of waiting, get accepted into a housing choice voucher, into the housing choice voucher program, only to find that the housing they wanted to transfer into was not accessible for their needs. They were a person with a disability. And so there was a lot of advocacy that happened to say, we don't want this person to lose their Section 8 voucher or their housing choice voucher after having waited for so many years. And a part of the program too, it requires you to be current on your rent. It requires you to, you know, follow the guidelines of your housing, whether that's the lease as well as the apartment complex or any community guidelines that are in place. And it also requires inspections, regular inspections and that sort of thing. So it is meant to promote housing mobility and allow individuals to eventually phase out of the program at some point. So thank you for that question. Alrighty, so in terms of the prohibited acts that we investigate, so the Fair Housing Act does not give a list of people who can be sued, but it does tell you what are some things that are prohibited. So a blanket denial of availability. saying that housing is not available because of a person's protected class. So whether it's because of their race, their religion, their national origin, any of those protected classes, that would be discriminatory. Providing a difference in terms or conditions. This is often seen with families with children, for instance. Maybe families with children are being charged a higher security deposit rate than someone without children, right? That would be discriminatory because the amount of a security deposit should be the same across the board. And it should not depend on that person's family status because that is a protected class. And something to note about that is, even if they're within their rights to charge the maximum, say 2 months of a security deposit, if they're not charging that maximum to everyone, but they're charging it to families with children, that could still be in violation of the Fair Housing Act. Restricting choice, so saying that a person has to live in a certain area, or say live on the first floor or on the second floor, or just dictating where that person will live. I've already mentioned discriminatory advertising, providing false information. This is often, just speaking to the level of not wanting someone, providing false information to dissuade someone from living in that area. Blockbusting or refusal to make reasonable accommodations or modifications. And this is a right that's available to people with disabilities. They have the right to request reasonable accommodations and modifications, which we can talk about a little bit more. But those are just some very clear examples. And I think that one thing to note with discrimination is that sometimes the actions can be very subtle and it's not very obvious, right? So when a person is being steered to a particular area, maybe that one individual is not able to tell, but as they're living there, they're able to see, oh, wait, why is it that all of the families with children are in this area of the community, but, everyone else, they're on the other side of the street, or, things like that. That could be an example of steering, and it's more subtle, difficult to detect, but that's where our investigations come in at EHOC. When you sense some of this is happening, we're able to go in and investigate further to find out whether it is happening on the basis of that protected class. So here's some other examples: screening, maybe asking a number of questions before stating whether or not housing is available. Voice profiling, providing different information or different terms or conditions, denying availability, any of those things that I just mentioned before, based off of how a person's ethnicity is perceived over the phone. And then also redlining. So this is a historic practice that barred people of color and Black people especially from being able to purchase homes. And there were literal red lines drawn around areas that lenders would not invest in, or homeowners insurance companies would not give insurance to individuals within those areas because they were deemed high risk. But the challenge with that is that the risk was being based upon that person's race. So if they were Black, they were considered high risk simply for the fact that they were Black. So what we see with that is a discriminatory impact, which means that it has a greater impact on those protected classes, even years down the line, which is what we see today. So when we enforce this, it's typically, we're filing complaints with HUD or the Missouri Commission for Human Rights or other state or local agencies, or sometimes we're able to do conciliations or make settlement agreements with those other parties to come to some terms of agreement without actually filing, or without a private lawsuit or other tools of enforcement. And then also there are private lawsuits that we could help to file. And then retaliation is protected. So with fair housing claims, retaliation is protected. It's something that is tracked even after the fair housing complaint is submitted. So I'm just going to briefly touch on this aspect. So with gender discrimination, I've already mentioned that it also encompasses sexual orientation and gender identity protection. So a person can't be told, well, you can only dress this way when you're out in public or when you're out in the community. We want you to dress a certain way to hide your gender identity or your sexual orientation. That would be discriminatory. Domestic violence survivors are also included under this gender discrimination. And so oftentimes they are impacted by nuisance ordinances that say you've called the police too many times, right? regardless of why they've called the police, especially if they are, you know, trying to get to a place of safety, or if they're in the face of their abuser. And with that, we see a disproportionate impact on those survivors of domestic violence that are then facing evictions because they're told to abate the nuisance, right? So that is a challenge that is faced, and that's something that we've seen on the rise as a result of the pandemic, along with sexual harassment, where housing providers may be taking advantage of this vulnerable, you know, situation with people facing economic loss, right? And with that, asking for sexual favors in exchange for rent, or making comments on someone's body or looks, or saying that, you know, they won't repair. One thing to note with sexual harassment is that the housing provider is liable for any action of their agents or their employees, right? So if it's the maintenance worker, the leasing staff, etc. One other thing to mention about is the HUD equal access rule. And this is basically stating that, you know, housing that's assisted by HUD must be open to all eligible individuals and families without regard to actual or perceived sexual orientation or gender identity or marital status. There are some exceptions for this, however, with single sex emergency shelters. One thing I've already noted with familial status discrimination is, you know, some of the prohibited acts. So those blanket denials of saying no children allowed, but also as it relates to the occupancy limits, where the standard may be 2 people per room. If under other circumstances, 2 people per room is allowed. However, because it's a mother and child, they're being forced to get a 2-bedroom apartment, for instance. But like I did mention, affirmative marketing is allowed. So with disability discrimination, this is a rather big one. With disability discrimination, this under the Fair Housing Act, the definition of a disability is any mental or physical impairment that substantially limits one or more major life activities. So these are some examples: blindness, hearing impairment, mobility impairment, recovering from drug or alcohol addiction, chronic fatigue, mental illness. Any of these could be examples of disability under the Fair Housing Act, and people who are protected are those who have a record of the impairment or regarded as having such impairment. What would not be protected would be someone who's actively using drugs, in contrast to someone who's recovering from drug or alcohol addiction, as well as those convicted of illegal manufacture or distribution of a controlled substance. So, as I mentioned before, reasonable accommodations is a right available for those with disabilities. And this means that someone can request changes in the terms of their lease or the conditions of their lease because of their disability. So handicap parking, lease reading accommodations, modified payments for Social Security income, etc. In order for it to be granted, it must first be necessary and reasonable for that accommodation to be granted. On the other hand, you have reasonable modifications, and these are changes to the physical construction of the property. So this is typically at the tenant's expense, but the landlord must allow it as long as they are completed in a workmanlike fashion. So this means like installing grab bars, installing ramps, say taking out a bathtub and installing just a shower floor so a person with a wheelchair can have access to their shower, for instance. So when making these requests, there's not a particular form that's required. It can be oral or written. And the reasonable accommodation process begins once a person tells a housing provider that they have a disability and that they need something changed in order to accommodate that disability.
So wait, so if you're, I'm sorry to interrupt, but so if you're a handicap and you need a wheelchair, so you have to build that ramp? The landlord won't do it for you?
Right. So in some cases, there are ramps that you can put like on the door that are removable, right? Yeah. That would not be a reasonable modification. Installing a ramp could be a reasonable accommodation in that case, that it's not changing the actual construction of the property. And in that case, if it is a reasonable accommodation, then it is on the landlord, as long as it does not create too much of a financial or administrative burden.
Okay, so what if you build the ramp and then and you decide to move and the landlord wants to keep the ramp?
Yes, they can do that. And sometimes if, for instance, they want to say, like in my example where I said the tub, right? If they want to put the bathtub back, the landlord may require a set aside to be paid once that person leaves with reasonable modifications, right? And so that set aside can be paid in installments, though. It does not have to be paid in one lump sum once that individual decides to leave.
Okay.
Good question. Any other questions? I kind of breezed through that information about fair housing rights, but I think it's important to know, when housing discrimination is happening, and hopefully with some of those examples you're able to see. We also have a plethora of resources on our website, really breaking down each protected class and some of the rights that are available, as well as examples for each of those. And so I'll be sure to share that with you all after this, if you all would like to share it with everyone. Awesome. So now on to landlord-tenant law. According to the Missouri landlord-tenant law, it's the tenant's responsibility to pay the rent on time, not to damage the property, do not allow others to move in without permission, and not to sublease the apartment to someone else. In the case that they do that, they can be charged double the damages in the case of an eviction. So it's something really important to note. And the landlord is responsible for providing habitable property, meaning very bare bones, plumbing, roofing, doors, bathroom, that sort of thing. That is habitable property. It's very gray. It's not extremely specific in Missouri landlord-tenant law, but we know that it's a very baseline. Also, they are required to make reasonable repairs, to give proper notices for rent increase, and to take the proper steps to evict for the non-payment of rent. So with proper notices for rent increase, this will depend upon that person's lease. So if you have a written lease, then it should be outlined in the lease when those rent increases would be in effect. Oftentimes it's at the time that you're re-signing your lease for the year, right? So if you have a 12-month lease, then whenever you're re-signing for the following year, they're going to tell you about any changes or conditions of the lease. If you are on an oral lease, you are automatically in a month-to-month lease, meaning that the landlord has a full 30 days before a change can take effect in that lease. So when it comes to notifying about rent increases or any other changes, then there's a full 30 days that has to pass before it takes effect.
I have a question.
Yes.
What's a reasonable rent increase?
That is a really good question. Reasonable is not determined. Well, one, there is not a law, a statute in Missouri that determines rent increases, or what amount, what percentage of someone can increase their rent, or even if there are limits in that, right? So that actually doesn't exist. And so reasonable is really given to the landlord to make that determination. Yeah, I would say fair market rent is a good guideline. Fair market rates is a good guideline because it kind of shows you the average of an area based off of the economy. However, with the way that housing is right now, everything is increased substantially. And even those fair market rates will be skewed because of this extreme increase in rent costs, in housing costs. So, I mean, yeah, that's a really, typically you would use that fair market rate to really be the guiding star of an area to say how much they should increase.
Is there like a negotiation that you could do? Like if you were to say if your landlord increases the rent by, I don't know, like $2,000, can you say, yeah, I can't afford to pay that? Like,
yeah, I think it's important to know that with the lease agreement, tenants have the right to advocate for themselves and say what they don't agree to or what they don't want, or if I'm going to pay X, Y, and Z extra, can I have an upgraded unit? Can I have an upgrade or, certain repairs to be fixed, etc. I think that it's important. That's where community is important, right? Because in some cases, we work with a number of grassroots organizations that work with tenants that say like, yeah, our rent is going up and our landlord, they don't even make repairs right now, you know? And so they gather together and they form a tenant union, and they ask of the landlord, like, we won't pay extra until these repairs are being made. And using that collective voice actually has power. Oftentimes that as an individual, you may feel a bit more powerless in those cases. So it's not something that is, I will say it's not something that is very clear or outlined, but we'll talk about a little bit more as it relates to repair issues, you know, what rights you do have at an individual level. But yeah, I think it's important to know in all cases of housing, whether it's the lease, whether it is, you know, facing an eviction and signing a consent judgment means that you're consenting to the terms. And if you can't agree to those terms, then don't sign it, right? That's important to know, that you have the right to not sign and consent to that agreement until it is something that you can agree to.
Okay.
Oh, you're on mute.
I have a question. I was gonna say, what is your opinion about oral leases versus written leases? Like, for the protection of the tenant, what's better?
Yes, absolutely. I mean, for sure, written leases are better, are preferred, because they are going to detail your rights. They're going to detail what you can hold the landlord accountable to. And so we would always encourage that. But it's also, I like to say at the same time, that just because you're in an oral lease, that doesn't mean that you forfeited your rights. It's still recognized as a lease, and you still have these rights available to you, even if you're on an oral lease. So while it's preferred to have a written lease, even if you write a lease up yourself and get the landlord to sign it, like, documentation is key with all of this, especially as it relates to your housing and the conditions of your housing. So thanks for that. So speaking of conditions of your housing, when we're talking about habitability, you know, I've already talked a little bit about how the Missouri landlord tenant law sees habitable property. So when you're going out and you're seeking housing, you want to walk through with your landlord or with the property manager or someone and go through and make sure everything is working. If it's not, take pictures of things, document the conditions of the home as you are moving in. Do that move-in inspection and take those pictures so that you can have that on hand. So when you're leaving and you're maybe they're trying to charge you for some things that was already there before you came, and you have that documentation to prove it. So written documentation like receipts, promises to repair, even the security deposit inspection when you're leaving. With repairs, again, document your contact with the landlord. We have templates that help people document the dates, the time that you requested something, as well as the response the landlord gave you, and maybe even take pictures of what was repaired, like the actual repair that was made, right? Keeping this evidence is extremely important to be able to assert your rights as a tenant later on down the line if there are further problems. So also calling an inspector in some cases is very helpful. So with the Missouri landlord tenant law, and this is what I was speaking to earlier, is that you have the right to repair or deduct up to $300 of your rent or half of it, whichever amount is greater. But, and it's a big but, in order to enact this right, you have to meet this criteria first. So you have to be a resident for 6 months, paid all rent due, not in violation of the lease, given the landlord 14 days to respond, which is why it's important to keep track of dates when you're asking for things, and to make sure those repairs are necessary. And this is where that report from the inspector can be useful as well. So if you find yourself in this situation, then you can either repair it yourself and keep the receipts and deduct that amount from your rent up to $300 or half, whichever amount is greater, or you can deduct up to $300 or half and have it in a money order, and you put it you put it in an escrow account with the courts, and that will help you to insert your rights as a tenant to get repairs made. It is not within the landlord-tenant law to say withhold all of your rent. That is not outlined in the landlord-tenant law. So it's something to keep in mind. I know sometimes we get really frustrated and really upset with the landlords and want to keep all of the rent. But what is allowed is this $300 or up to half of your rent, deducting that amount if you meet this criteria. So when we talk about the proper steps for eviction, and I will be wrapping up shortly, first, the landlord must demand a payment for the past due rent that's owed, and that's given their written notice of their intent to evict you. That's oftentimes the 30-day notice. This is just the first step, right? Oftentimes people believe that because they get that 30-day notice, oh, I need to leave now. I need to get out of here. And sometimes if the landlord is wrong, then it is an easy solution to their problem, quote unquote, right? That they expect, oh, well, they're going to leave after 30 days anyway. And that way, when they abandon the property, they didn't actually go through the filing of an eviction whatsoever, which means you also don't have an eviction on your record, right? That's important to know. Out of this pandemic, we see so many people that may believe that they got an eviction just because they got this letter about their intent to evict you, but they didn't actually file. So keep that in mind. So after that, that's the first step. Then you must be summoned to court. This summons can either be delivered to you in person or it can be posted on your property. Both of them are sufficient for saying delivering a summons, right? And then the judge must rule that the landlord is entitled to the possession of the property. So that is when the eviction actually has taken place and there is a rent in possession charge on your for you, against you. Yes, a written possession charge against you. Within 10 days after the judgment, the landlord can then file for the eviction order to be executed, and then the removal from the property must be overseen by the sheriff's office in order for it to be legal. So the landlord cannot just come in and change the locks if they haven't even gotten a judgment from the judge didn't rule in their favor, or that sheriff's office didn't come out and actually evict you from the property. One thing to note is that you can appeal an eviction as of 2014. Basically, this means that if you disagree with the judgment that the judge makes, you can file for an appeal, right? But this will not stop you from being removed from the property. That's important to note. The only way to stop yourself from being removed from the property is to pay all money that's owed and the court costs. Pay all the money that's owed and the court costs, and you have up to the day of that trial to do so. It's called pay and stay. And if you do that, then you're able to stay in your unit. So that's really important to know. While you can file for an appeal, it does not necessarily protect you unless you've paid all money that's owed in the court costs. So as far as evictions, the landlord cannot just come in without going through this proper process, without being overseen by a sheriff. The landlord cannot come in and just change locks, remove your belongings, shut off your utilities, board up your windows or your doors, or any other way that they try to illegally lock you out of your home. That would be considered an illegal lockout. And we have a letter that we can send on your behalf to the landlord. You can call the police and let them know that you're being illegally locked out, as well as just calling them and letting them know that you know that that is illegal what they're doing, and advocating for yourself. In some cases, you are able to use a reasonable force to enter the property, but you would be responsible for the repairs. And I would say that that would save that for emergency situations. Say, for instance, your medication is locked in your home and you're not able to get to it, and this is an illegal lockout. So finally, we talked about security deposits a little bit earlier, but this is the amount of money that's supposed to cover damages that a tenant might cause during their stay. So the maximum, according to the Missouri Landlord-Tenant Law, should be the value of 2 months' rent. That's the maximum allotted security deposit amount. When you conduct that move-in inspection with the landlord and conduct a move-out inspection with the landlord, then you're able to see if there are any damages that that landlord may be charging as a result of you leaving. The landlord must return the deposit or provide a written list of these damages within 30 days after you move. So you'll want to just make sure that you've given them written notice, do your part to clean, leave the apartment clean, and leave your home clean, do a move out inspection, return your keys, get a receipt, provide a forwarding address, take pictures and save them so that you know the conditions that you've left it. And then from there, if they have not returned your security deposit and they have not provided you a list of written damages, then you can make a claim with small claims court, as long as you've made a written request to get your security deposit back. You can make a claim with small claims court and be entitled to double the amount of that security deposit. All right, and that is the end of our presentation today. If you have any questions, you can contact EHOC. And this is our phone number, as well as visit our website. Like I said, there are a number of fact sheets there, and I'll share some with you all as well. You can find more information.
Okay, so we do have a couple of questions. Have you dealt with wrongful evictions?
I'm sorry?
Have you dealt with wrongful evictions?
Yes. Our eviction defense team works with people who have been wrongfully evicted often. Yes.
Can you give us
what
an
are
example?
the most common what are the most common reasons for or causes of a wrongful eviction?
Yeah, so sometimes you'll see where a person is being evicted because of, I would say, faulty claims. So for instance, if they're saying that they owe X number of dollars, but they've received money or they've already paid, they have receipts that they've paid, and the landlord is showing that they haven't paid, but then they're requesting their ledger and that's not available to them, but they're just evicting them and going through with the process. Oftentimes, when attorneys are present, obviously, there is a added bonus or added protection that tenants feel to be able to advocate for themselves in those situations and say, no, we know that we have the documentation to prove that I've paid, or I have the statements to show that I've paid, and the landlord is wrongfully evicting me. So in some cases like that, that could be an example. In other cases, we will see where it is an issue that a tenant has withheld their rent, right? And it's because of repair issues. And so when a tenant is able to show in the courts that that they actually have these repair issues that have been ongoing and the communication that has happened with the landlord regarding those repairs, then oftentimes the judge could just decide to dismiss or rule in the favor of the tenant because of the fault of both of the parties, whether it's because they withheld all of their rent or whether it's because the landlord has not actually made the repairs that have been requested of
them. Do you see single mothers facing a lot of housing discrimination?
Yes, actually, we just released a report on evictions just last year, and as a result of, and I'll just stop sharing my screen actually. After the pandemic, we did a study of who was being impacted most by the pandemic and the eviction crisis that was looming, and we found single mothers with children of color especially were being evicted at higher rates. And with that, that's why we state that the eviction crisis is a fair housing crisis, because they are a protected class, and we see it often, way more often. I think even a large percentage of our clientele are women with children.
Would it be called discrimination if I were to ask what kind of people live in this neighborhood?
If you were to ask what kind of people live in this neighborhood, it's an interesting question. So oftentimes the way that this is framed, it's in limiting the choice of the individual who is seeking housing, right? So if a realtor is telling you that, you know what, you'll feel more comfortable over here because there are people like you over here, that would be discriminatory, right? Fair housing is trying to protect the rights of the individual to choose where they choose to live, where they want to live, right? And so if they say, I want to go to a school where there's a majority, Black population in my case, then the landlord, or I'm sorry, the realtor needs to listen to me in terms of saying, okay, this is where you'll go. Or I want to go to a school where there's not very many Black people. Well, send me over to the areas, let me find that research on my own. But that's where the discrimination sort of becomes a little challenging, because it's from the perspective of those who are either assisting in the housing buying process, or in, a homeowner or a housing provider, then deterring you one way or another.
What issues do immigrants face most frequently when it comes to housing issues?
Yeah, so I would say some of the things that we see, one would be language barriers, right? Just from a basic level, not feeling that they have the tools necessary to advocate for themselves because of language barriers. And then also other things that we've seen would be not knowing, like, just as a lot of people, just not knowing their rights, not knowing that their rights still apply, especially as it relates to sometimes immigrant status and different things of that nature that may come into play, especially when landlords may be trying to harass or threaten on the basis of that immigrant status, or because of how they perceive the person's immigrant status to be. So those are some things that we definitely see. And the thing with the Fair Housing Act is that's not national origin. Immigrant status is not an explicitly protected class in the state of Missouri. In Illinois, it is. And it's something that I know advocates from St. Francis in the past, St. Francis Community Service has worked to, get that added as an ordinance, as an additional protected class at a local level, but it has not yet passed. So yeah.
It's interesting that you bring up Illinois, because someone told me about a case in Illinois where a landlord refused to rent to somebody unless they showed them their green card. And the landlord got in trouble. There's no requirement that they had to show them a.
Exactly. And that would be discriminatory from a face value, even here in the States, because that goes to that screening piece that I talked about, right? Where if I hear that a person may have an accent over the phone, I'm going to ask them for a green card, or I'm going to ask them for their citizenship paperwork, when I'm not asking that across the board to everyone else. That could be a national origin claim.
What about if you're undocumented? Because, they need to live somewhere.
Exactly. Well, and that's what I was stating, is that it's not explicitly protected at a local level, but I think that there are ways that national origin protections still apply broadly. So if the landlord, and we actually don't ask immigration status, so we help people regardless of their immigration status. That's not a question that we ask. It's not a requirement for us to ask it when we submit complaints to HUD. Based off of fair housing. So it is something that we're still able to assist, people who are getting discriminated against. And I would say people may not know that, and that's where they don't assert their rights, because they may think, oh, well, I'm undocumented, I don't have any rights. But the Fair Housing Act, it's not something that we're asking explicitly.
What constitutes as reasonable repairs?
Good question. This is another one of those things that in Missouri landlord tenant law, it is not explicitly outlined to say what is reasonable or not. And that's why an inspector's report is helpful. Plumbing issues, right? Issues with the structure, the foundation of the housing, that is on the landlord to repair oftentimes, most times. And that's where you bring in someone from, if you live in St. Louis City, then the Citizen Services Bureau, and they'll be able to send out an inspector, a building inspector, to check and see, is this a issue that the landlord is responsible for? Is it a building, a foundational issue? Or is it something that you caused?
What about lawn treatment?
Lawn treatment. That's a good question. In terms of like someone who is renting a house, say for instance, I think I would wonder if that is outlined in their lease, right? So then we go back to the lease to see. There isn't anything at the state level, but maybe at a municipal level or at a local city level, right? There are ordinances, and that's where nuisance laws come into play as well, right? When the grass is too high or certain things, but the homeowner is typically the one liable for that, unless it's outlined in that lease that that tenant is the one that's responsible for it.
No, I mean, I understand cutting the grass and everything, that's for the renters to do, but what if you're actually investing a lot of money on the lawn? But wouldn't that be like the landlords?
That is questionable. I think that would depend. It would depend if they're being forced to do this because of a habitability issue versus a desire to do it just to make their property look better. It's likely not going to be on the landlord.
Oh, okay.
Marissa, one of the things you touched on in your presentation was, when people are looking for a home or to rent and they can't get a loan. Can you talk a little bit about that?
Yes, it's something that is really challenging, honestly. And we actually have our St. Louis St. Louis Equal Housing Community Reinvestment Alliance, SLECRA, acronyms. Here we are. SLECRA, and I can share the website with you as well. SLECRA actually helps to promote home ownership and looks at the that disparity within home ownership and lenders who provide product to people, because there is a requirement under the CFPB, all of these acronyms, the Financial Protections Bureau, they require banks to lend to low to moderate income individuals, and they get scored on their rates of doing so. So it's called the CRA, the Community Reinvestment Act, right? That really does look at how often banks are lending to these populations that have been historically disproportionately impacted by discrimination, housing discrimination, and their likelihood of getting loans for housing. And so our SLECRA Alliance actually works with lenders and community members that advocate for those products to be accessible, so that we can make sure that we're addressing that gap in how people are able to access home loans for home ownership. We actually just had a conference too, all about home ownership and racial, I would say the disparity between home ownership when it comes to people of color because of historic practices. So appraisal biases are another thing that's really right now.
Interesting.
The data research.
Marissa, could you share the eviction report with us? I think that would be something. Yeah, I think that would be something that would be good for us to share on our website or Facebook page.
Definitely. I'm going to make a list. I'll also just share with you all where a lot of our fact sheets are. We do have fact sheets available in multiple languages as well. So if you all want some translated,
that would be great.
That would be awesome.
Yes, definitely. I'll make a note.
I think we are good with the questions. Yeah.
Great questions. Thank you all.
Thank you so much for doing this.
Awesome. Thank you. Thank you for inviting us. We really appreciate it.
This was so helpful.
Yes.
Definitely.